You guys. How's it going? How's it going? Welcome to the live. Sorry I'm late. I'm going to give a few minutes for everybody to get in here, but including somebody who might be able to join us, he was saying, is Doug Weinstein, who I talked to yesterday, but he is the one who brought the recusal motion against Judge Glanville today. He said, he's busy. He said he could come on at 5. I wasn't quite there. Blah blah blah. He might sign on if he can for a few minutes. But the big news is Brian Steele is not going to jail. And to be clear, I think everyone expected the appellate court would do this. I mean, it was really kind of a bold move by Judge Glanville not to grant not to just stay it pending appeal himself, because I mean everybody figured they would do this. The chances of Brian Steele actually going to jail on Friday, I think most people thought the appellate court would step in. But here's Doug Weinstein. Let's put him on the stage. Doug, thank you so much for joining us again. It was quite a day in court. Your motion to recuse Judge Glanville. I'll have to bring it up on the screen here when I can and go through it. But if you want to talk about the substance of it, that would be great. But I was wondering if you could address Georgia state law on when judges consider their own recusal motions, if there's different standards for that or how that works.
Yeah, there's a very clear procedure in the Uniform Superior Court rules of Georgia of how a judge is supposed to deal with a motion for recusal. So when it's presented to the judge, which is what I tried to explain to the judge today, when it's presented to the judge, he's supposed to take a look at the motion and see if it's timely filed. We have certain time requirements, like you have to file it within 5 days of whatever incident that you learned gave rise to the recusal. It's supposed to be filed 10 days before trial begins, unless you have good reason. In this case, we think we have good reason because we're 18 months into trial and this just happened. But once he determines whether it's timely or not, then he looks at the affidavit. So you have to have an affidavit, and the affidavit has to be very specific, which is why the affidavit, if you look at it that I submitted, has a lot of detail of what we believe happened, or what I believe happened. So if that's sufficient, then the judge has to assume everything in the affidavit is true. And then he has to look and see, assuming everything in the affidavit is true, would that merit recusal? And if it would, he has to refer that out to another judge to look at, to make a determination.
Recusal from the recusal motion, basically. Would it warrant his recusal, or is the standard, would it warrant his recusal from considering his recusal motion?
No, the question is, would it warrant his recusal from the case?
Okay.
Because in Georgia, the judge does not consider their own recusal motion. Basically, and this is going to be the wrong word, but basically if you make a prima facie case on your pleading, on your motion, that recusal is warranted and it's done in a timely fashion, and I'm oversimplifying it, but then he should refer it out to another, in Fulton, it would be another panel of randomly selected judges to make that call on recusal. Now, I believe the case could proceed, as I read it, while the recusal decision is being made, but that's a little unclear. So I don't think it would have delayed the case. But that's not the procedure the judge decided to use today.
Yeah, and he kind of warned you about what you'd included in the pleading. Said, warned you to tread lightly here. Is there any response to that? Can you respond to that, or?
Well, I mean, when I learned what I learned on Monday, I felt that I had an obligation to my client, and to some degree to the court, to file this motion. I don't think I had an option on that. We haven't seen a transcript of what happened on Monday morning. Perhaps what I learned is wrong, which is why, perhaps my source gave me information incorrectly. But if so, I think that should be up to a panel of judges to look into that and decide.
Yes. And is your I'm not gonna get into the sources, but is the same type of information that Brian Steele presented on Monday? And sorry.
That's good.
It's got a little distracted there. That Brian Steele presented on Monday, and he was careful to say he wants to make sure this is true, right? I mean, you guys are saying on information and belief. Is that the wording in the pleading?
Right. We're in exactly the same boat. I mean, I was very careful that if it was something that I didn't directly have firsthand knowledge of, I stated that it was on information and belief. Um, so I, to the best of my knowledge from what I learned, what I put in the affidavit is accurate. I mean, it certainly reflects what I learned about what happened Monday morning. If it doesn't accurately reflect what happened Monday morning, and part of me hopes it doesn't, because what is in the affidavit is really um, troubling.
Yeah. Especially, I mean, for all defendants, it's troubling, but it seems like there's a lot of stuff in there about Donovan Thomas's murder, which is really why Woody was placed where he was placed in his witness order. Is we're right in the middle of hearing about all that, and your client is actually one of the ones who's charged not only with the RICO conspiracy, which includes Donovan Thomas's murder as a overt act, but he's actually charged with the murder himself. He and Shannon Stillwell, right, who were both on trial.
That's correct. There's several people charged with that murder. Two of the people charged with the murder, including my client, Diamante Kendrick, are in the trial right now. Mr. Kendrick did not commit that murder. And I think that when all the evidence is heard, the jury will come to the conclusion that he's not guilty. But, we're just very troubled by what we learned happened on Monday, especially some of the things that that was told to me that the DA's office did. I don't believe in the presence of Judge Glanville, because I don't think he would put up with it. But what the DA's office allegedly said to Kenneth Copeland is really troubling.
Yeah, you said you don't believe in the presence of Judge Glanville. Are you questioning like whether he allowed prosecutors to just talk to Kenneth Copeland alone, or what did you mean by that? Oh, little shaky connection here, but maybe we can get into the. Can you talk about what is the most alarming thing that you heard about that went on in the meeting, other than just the fact that the meeting took place?
Well, yeah, I mean, we can get into the fact that the meeting took place and that we weren't notified of it, and we weren't made aware of it before, during, or after. If it wasn't for this source, we probably wouldn't even know it happened. I guess one of the more troubling things is hearing that in the course of the meeting, I know there's so many troubling things, but hearing during the course of the meeting that Mr. Copeland told the DA's office that he basically, if they insisted on putting him on the stand, he would just get up there and lie. And what we were told is the DA told him, "Yeah, you lie. We're not gonna prosecute you if you lie." And then he said, "Well, I'm going to get on that stand and say that I killed Donovan Thomas," which, I mean, he may well have killed Donovan Thomas. I'm going to get on there and say that, and the DA's response was, "Well, if you say that, we are going to prosecute you for perjury in that case and false testimony."
For perjury, because
Because they believe he did not kill Donovan Thomas.
Yeah, and that's their whole case. If he really did kill Donovan Thomas, then they'd have to drop the charges, or if they had any knowledge of that. But that's the kind of thing that's an exculpatory statement under Brady versus Maryland, right? Which is what Max Shard raised before court let out today. I mean, those statements are pretty crucial to you, right?
He's raised it multiple times and asked that if there was any additional Brady material that we be provided with that, any Brady material that may have come up in that meeting. And so far, we have not been provided with any Brady material that may have come up in that meeting. So perhaps our source didn't relay accurately what happened, or I don't know what's going on with that Brady material.
What was interesting to me was that, I mean, like has been established, you were not going to find out about this meeting unless Brian Steele had learned about it from somebody who he won't disclose to Judge Glanville. And what I've heard is, ex parte, it was, a lot of people say it was inappropriate to have this meeting in the first place, but to have an ex parte meeting like this and not notify the other side is just totally totally wrong. But what was alarming to me was Glanville's answer to Max Shard that he's still combing through everything to see what's releasable. So he seems to acknowledge that there could be stuff in this conversation that's releasable. But if he had it his way, you guys still would not even know about this conversation. Is there anything you can say to that, or is there any kind of talk amongst the attorneys about that?
Well, I'm not going to go that far. I don't know that at some point the judge may have notified. I can't get into his head to know that absent our learning of it Monday, he wouldn't have told us about it. But and I don't want to make that guess.
Okay.
Um, but the judge's position on providing us with that transcript has changed over the last 3 days. I believe initially when Max requested that on Monday, it was a flat out no, that the Court of Appeals would get that and then they could make decisions based on that. And then I believe Tuesday it was some version of that he is considering it. And then you just relayed what the judge told Max today about it.
Yeah, yeah. And for I just went live on TikTok, so people know who they're hearing from. It's Doug Weinstein, who is Yak Gotti's lawyer. He's the one who brought the recusal motion against Judge Glanville today. And we talked a couple nights ago, and you'd said that you were going to be writing something that night. Was that the motion that you started writing that night?
Yeah. I've been working on this along with the whole team at the App law firm, Jay Apt and Katie Hingerty.
Yeah.
We've been working on this for a few days now because we really want. It's very critical in these recusal motions, at least in Georgia, that you dot every I and cross every T. Because there is a very clear procedure that the judge needs to go through that I relayed to you earlier, and it's easy to make a mistake in presenting what you need to present to the judge so that when they go through the procedure, you can get that referral out to another panel that you need.
Yeah, yeah. And now you're not obviously involved in the litigation regarding Brian Steele's contempt order. He has his own attorneys, but you're kind of got a front row seat to all of that stuff. And can you talk about what was the feeling that he would actually have to report to jail on Friday? Did you think that was going to happen?
Well, we were all hoping it wasn't going to happen.
Yeah.
And we were hoping that he could get an expedited appeal, and that he could get that supersedes bond that we believed he should get. So we were very I mean, I haven't talked to anybody else since I saw that he got the bond from the Georgia Supreme Court, but we're all very happy that he did get that. And the other thing was, I don't know if you reported on this Monday or not. I don't recall, because I feel like these 3 days have taken 3 months. But to watch GACDL, the Georgia Association of Criminal Defense Lawyers, swoop in there and show so much support for everybody was fantastic.
Yeah, Ashley Merchant really schooled Glanville. I've got that. It's a 20-minute video of her kind of explaining the differences between civil and criminal contempt for him. But I mean, she's so well known for the Trump stuff, but really she was there as president of the Georgia Criminal Defense Lawyers Association. So I noticed that she's the attorney on the Georgia Supreme Court appellate case, but then the Georgia Defense Lawyers Association has actually filed notice as a amicus appellate. So should we expect some kind of brief from them, or do you know about that process?
I do not. I don't. I have not been involved in that, so I don't know.
Okay. Well,
Yeah.
what's coming up? Is there any recourse for you with him rejecting your motion? Do you have to wait until there's a judgment here and then you can make that part of your appeal?
Well, if you watch today, I did request the judge to give me a certificate for immediate review. So I was hoping to be able to use that to go to an appellate court to have them review the judge's decision that was made today. And what I was trying to, and maybe I didn't do it artfully enough, I was trying to explain to the judge that I thought it was beneficial not just for the parties, but for the court to have this appellate review that the judge is always referring to, where he says, well, an appeals court will hear that eventually and they'll decide if I'm right or wrong. But I thought it would benefit everyone if we could go ahead and have an appeals court look at that right now. And if the judge is correct and if nothing wrong happened, well, I think that really does improve the situation at the trial. And then if we're all right, well, appropriate action will happen. But he did not give me that. So we're looking at what other avenues we have to pursue to see if we can, because we do believe, at least based on what we've heard, that recusal is warranted. Judge Glanville is a very good judge. He has integrity. I'm not quite sure why we're in the situation that we're in today, but I think it would be beneficial if a third party, if another set of judges were to take a look at what happened and then make a decision.
Yeah. Is there any thought that there might have been other ex-party meetings going on that you don't know about? Or, I mean, it seems like you found out about this one pretty fast. So is there some thinking that you would have heard about others, or what's the thinking on that?
You know, secrets are really hard to keep, which is why all these conspiracy theories that float around are just so ludicrous. Um, but it makes you wonder if there have been other meetings that we have not been made aware of. You look back at all the late start times, where the prosecutors kind of show up a few minutes before the judge does. But I have absolutely zero basis to think in reality there has been any other ex parte meetings, and what I'm trying to do is not become paranoid at this point.
Yeah, yeah, yeah. Oh, regarding Brian Steele's bond, when they say bond, is there going to be a monetary amount here? Is he going to have to go find a bond company and pay 10%, or is that just automatic own recognizance?
I don't know the answer to that, so.
Okay.
And I'm sorry, but I am going to have to drop off. I think I
Sure.
mentioned I couldn't stay on that long, but I am glad I got to sit on at this point in time. And yeah, I guess I do just want to close by repeating that I do respect Judge Glanville, and though it can sometimes get heated in there at times, I think we all do our best to remain professional with each other, including the judge. Okay.
Yeah. I mean, I see a lot of recusal motions, and they're not to be taken anything personal against the judge. It's part of litigation, and I think we heard that brought up in the.
Yeah. But if you're the judge, it's hard to not take it personally. Okay, I got to go. Thank you very much.
Thank you so much for joining us.
Bye.
Thanks. That was great. He was. So yeah, hi to TikTok. I didn't want to interrupt when I had Weinstein on the line, and I got to figure out a way to do the double up so the TikTok people can see the screen too. But we had him on the StreamYard for YouTube. So yeah, another exciting day in the Young Thug trial. The big news being Brian Steele is not going to jail. Let me pull up the actual order from the Georgia Supreme Court. I'm not quite sure. It was just a procedural thing, but they filed it in the appellate court, and then the appellate court kicked it up to the Georgia Supreme Court. But it happened pretty fast. And it's not really a written opinion. Well, it's definitely not a written opinion. It's just a quick one-line thing. The order is granted here. I'll bring it up here. Somebody, people. It is freedom of speech around here. As long as you don't get, one, racist, and two, just kind of nasty. You can say whatever you want in my chat. I don't really care. But I'm actually hiring a friend to go through some of the videos that have really big comment things and delete all the racist stuff, because it's like, okay, my channel's getting really big, and I gotta do something here. But let me see here. So yes, this is it. It's not much. Like I said, it's not much to look at all, but it just says right here, all the justices concur except Peterson, presiding justice is what that means, not participating. And I don't know why they're not participating. I wouldn't read anything into it. It could be something perhaps conflict related, or it could not. I mean, they could be like on vacation or something. I don't even know. But yeah, so it just says supersede is granted. So he's not going to jail on Friday, and then the appeal is still pending. So he still technically has the contempt order against him from Judge Glanville. He just doesn't have to go to jail on Friday. And as his attorney pointed out in the statement to Joseph at the Atlanta Journal-Constitution, it's Father's Day weekend. They're like, we're glad that he's not going to have to be in jail on Father's Day weekend. I'm like, oh yeah, I had not thought of that. That is this weekend. But let me see here. Yeah, here it is. He says, we are thrilled that Brian will be home with his family for Father's Day this weekend. We appreciate how quickly and thoughtfully our appellate courts handled this unfortunate situation. And that's Ashley Merchant, who looks like she's taking the lead for Brian Steele on it. But that's Joseph from Atlanta Journal-Constitution, who covers the YSL trial. He got that statement directly from her. And this is kind of nothing now, but this is the Georgia Court of Appeals transferring it to the state Supreme Court. I'm not quite sure why. It's basically they're like, this is a criminal case with ultimate jurisdiction there, so here you go. But this is Weinstein's motion to recuse. Let's bring that up here, because I didn't want to talk to him too much about stuff that's just in his motion, because we only had a few minutes with him, because we can just go into the motion and pick it up ourselves. But the stuff about what they think happened in that meeting is pretty crazy. Let me I hope everybody's doing. Thanks for tuning in, huh? Okay, so here is actually let's do this. How does this look here? Yeah, so let's scroll down quickly to what they say happened in the meeting. Oh yeah, this is the big stuff. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. And obviously this is all, if this actually happened, they say this is from somebody who was in the meeting who told them about this. This would be considered Brady material, because, I mean, it just goes to his credibility on the stand right now. It's like, well, 10 minutes before he took the stand, he told you guys he was going to lie, and you guys just decided to take his word a few minutes later that, no, actually, he's not going to do that. I mean, that's clearly something that they could use in defense, because the standard for this Brady stuff is, I mean, what's exculpatory? And courts have ruled that it's stuff that could potentially be exculpatory, because it's kind of the nature of jury trials and fact finding is, what are they innocent or guilty? And of course, the defense is going to say something is totally exculpatory, and perhaps it's not. But something like this seems, if he actually said stuff like that, all that is stuff that would need to be released, I think. Upon information and belief, sworn witness Copeland also testified to ADA Hilton that he would testify that he killed Donovan Thomas Jr. And remember, Woody was actually charged initially with Donovan Thomas's murder, but he was never convicted, and prosecutors have changed the tune on it. Now they've got, I think it's 5 YSL defendants total who are charged with like murder one for, or I don't know if they count in Georgia as just murder, but the only 2 on trial right now are Shannon Stillwell and Yak Gotti, but I think there's like 3 other defendants who've got that murder rap. And Copeland isn't one of them. Obviously, he's currently out of custody. He's not charged with murder, and obviously prosecutors do not believe that he is the one who killed Thomas. So they were saying, and one, we don't have the benefit of actually being there and knowing the tone of Copeland when he was saying this, but when he said, well, I'm just going to get up there and testify that I killed Donovan Thomas, Hilton thinks that he's lying, like that he is not actually the one who killed Donovan. So she tells him he's going to be charged with perjury. But this is like really crucial stuff that, yeah, you can see why the defense thought they should be here for this. And upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. This is all in the recusal motion that Doug Weinstein brought today. So like I said, that was kind of the good stuff that I wanted to get into immediately. But let's start at the top here, and you can kind of read aloud how exactly they wanted to get the judge off the case here. And let's see here. Motion to recuse. Well, it's interesting because, I mean, Weinstein was saying he doesn't He doesn't think the proceeding needed to be halted for this, but up top, his recusal motion does say that he's requesting that the present trial be temporarily halted until the present motion is heard by another judge, of course, but that could be like, an hour or something. But it does seem like that was Glanville's immediate response was he's not delaying the trial. But so they're quoting a state Supreme Court case from Georgia, 2018. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that a court should be fair and impartial. That's Mondi versus Magnolia Advanced Materials. I wonder what kind of drama happened with the judge in there to warrant some kind of binding appellate court decision about it. I'm sure it was. You can fall down these rabbit holes doing this too. It's like, oh, whatever you do, don't copy and paste that and put it into Google because you'll get on a detour and not come back. But the present case involves a 65-count RICO indictment against 28 individuals. This is just the background that they have to include jury selection in 2023. Given the state has presented less than half of its current witness list, which the state has announced could be increased based on circumstances, I hadn't heard that, the trial should last well into 2025. The 6 defendants presently on trial, including Mr. Kendrick, this is Kendrick's lawyer who wrote this, so, have been denied bond and incarcerated for over 2 years. It's crazy. Let's see here. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. On Friday, June 7th, 2024, Kenneth Copeland was sworn in. Despite being sworn by Chief Judge Uriel Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, Copeland refused to testify on that day. And he cites his own affidavit, Weinstein, because he's like the witness to this. He saw it with his own eyes. Copeland was ordered and incarcerated by Chief Judge Glanville on that date. Was ordered incarcerated. And Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th, 2024 at 8:30 a.m., where Copeland would announce whether he was prepared to testify. We all remember that. And at the time, we all thought that was the biggest drama, right? Oh man, Kenneth Copeland arrested for contempt. This is crazy. We had no idea what was coming with Brian Steele, did we? Let's see here. On Monday, June 10th, 2024, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m. Admitted entrance into courtroom 1C and asked within, and excuse me, I've got terrible eyesight in case you guys got notice, and seated within by 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Attorney Brian Steele, counsel for defendant Mr. Williams, inquired with the court as to the delay and what had occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. Unknown to any members of the defense counsel during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Chief Judge Uriel Glanville's chambers on June 10th, 2024, among Chief Judge Uriel Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. And Copeland's attorney, remember, I don't know if you all know this, but she's on the hook now. She has a contempt hearing, show cause, which means she's basically got to show why there's cause not to hold her in contempt. And anyone else who was at this meeting is supposed to be at a hearing in Judge Glanville's courtroom on June 25th. So he, especially with the order against Brian Steele, I'd expect him to kind of go off a little bit. I don't know if the appellate court ruling will take him down a little bit, but we'll see. June 25th should be some high drama, but no member of the defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. Yeah, it's pretty important. Upon information and belief, neither Chief Judge Glanville nor any member of court staff nor the Fulton County DA office made any member of defense counsel aware of the ex-parte meeting, either before the ex-parte meeting was held, during the ex-parte meeting, or after the ex-parte meeting. Copeland briefly testified prior to a lunch recess. There, Glanville, he's just constantly going on breaks, comfort breaks, lunch. And one thing he always does, gosh, and I should have just started counting when he did it, but he'll take a break. We're going to take a comfort break for 10 minutes. 35 minutes comes by and they get back. And then he's like, you know what? Let's just go to lunch. And it's like, why didn't you just take lunch? Anyway, but upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. That was, of course, after he was asked his age. So it was kind of this defiant, bullshit fifth plea. But, that is what happened. But upon information and belief, Copeland stated that he would sit in jail. Oh, excuse me. That was what happened on the stand. And what I just read was actually referring to what happened in the ex-parte. Excuse me. So it wasn't when he was asked his age. Well, we actually don't know exactly what he was asked when he said, but it wasn't in the middle of testimony. It was Glanville saying, are you going to testify? And he said, no, I'm going to plead the fifth again. Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief, Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried. Not just the 6 defendants currently on trial. God, that's crazy. Yeah, because that's could be a lot longer than 2 years. And that's one thing that's kind of unspoken about this is with all the defendants that have been severed, this is just going to be the first of many trials. It's crazy to think that they're going to try to repeat this trial many, many different times. But that is what they're going to have to do if these severed defendants take it to trial. So ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above course of action by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex-parte meeting that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex-parte meeting. Copeland stated to Hilton that if called to testify, he would simply lie on the stand. This is what we saw earlier, the good stuff, as I said. In response to Copeland's statement that he would lie, ADA Hilton stated that he would not, or she would not prosecute witness Copeland if he were to lie on the stand. And that, I'm like, I don't know, but the Donovan Thomas stuff caught her position. I'm like, and as Weinstein said, he hopes the stuff that he heard about this is not true. Oh, did somebody say they can't hear me? That's on TikTok. Sorry. Yeah, I got to figure out how to double it up a little bit better. But gosh, we've got almost 2,000 on YouTube here. We gotta keep it going. But I appreciate all of you for tuning in. I'm trying to figure out how best to serve you. I just moved to a new place, so I've got getting the YouTube live setup going on. But in response to Copeland's statement that he would lie, Hilton stated that she would not prosecute Copeland if he were to lie on the stand. Copeland also stated to Hilton that he would testify that he killed Donovan Thomas. In response to Copeland stating that, Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. During court on the afternoon of June 10th, when one or more of the above allegations were presented to the court by Attorney Steele, that's what led to his contempt ruling. Because Glanville was immediately just like, how did you hear about this? Tell me who heard. And he's like, I'm not. I remember Glanville was like, I'm disturbed that you know this stuff. And Steele's just like, well, I'm disturbed too. It's like, yeah, what? I mean, he was completely changing the subject to just turn it all on Steele and wouldn't even talk about this meeting that they had. But when a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient. And they check all those boxes easily here. And whether the affidavit set forth facts that, if proved, would warrant the assigned judge's recusal from the case. So this is the great Magnolia judge recusal case in Georgia of 2018. Like I said, I might have to fall down a rabbit hole with this one tonight for some bedtime reading. The Mundy versus Magnolia advanced materials. But and of course, just so everyone knows as we're going through it, because I know people are going in and out, Judge Glanville did not recuse himself. I mean, he so fast. I don't know if they brought it up before, and I think he mentioned something about it, but I just heard them come back from a break or whatever, and Glanville's just like, well, I read your motion and I'll be denying it. And it was like a 5-minute exchange. I've got it on my the YouTube channel. I think the clip's on TikTok too. But if you guys want to read the actual motion, go to my Twitter page, and I've got it linked on there. You can find the link to Document Cloud here. I can put it in the chat for StreamYard, but I don't think I can do anything on TikTok for it. But I need to get I want to do something with my website where I can get everything in one spot kind of thing. Have all the documents on there and everything. But anyway, timely manner. Yeah, I mean, all the stuff about, affidavit, timely manner. Of course he hits that. Let's see here. This is all, I mean, it's kind of procedural. Like I said, we got into the good stuff with Donovan Thomas. This is just, we're going through the pages, him explaining his motion here. Must be assumed to be true when deciding whether recusal is warranted. And I'll bring up the clip here, but Glanville was like, bias. You need to be saying bias. And yeah, I mean, they could have argued that. I think they totally could have argued that here. But I thought it was funny in the clip when Judge Glanville was denying this. And he said, if I had said something bad about, you or your client, I'm like, that time you told Max Shard he wasn't a good advocate because, like, he hadn't done something earlier or something like that. I thought that was, like, kind of a low blow on Glanville's part. I'm like, well, maybe Max Shard to try to recuse you over that. But let me see. The details learned by Weinstein upon information and belief detail the holding of an improper ex parte hearing. And really everyone I've talked to agrees. Like, to hold an ex parte meeting at all just seems improper in a trial like this, a criminal trial. But people have said that if he was going to hold this ex parte meeting, he needed to notify defense counsel. And it's kind of surprising that, I mean, Glanville, I don't know. I mean, because he very easily could have just been like, Steele, I'm doing this and tough shit. You can't come in. But gosh, who knows what Steele even would have done. But yeah, the fact that he didn't even tell him about it. But, as Weinstein said in our interview earlier, he's not willing to say that he doesn't think Glanville would have ever told them about this. But I'm like, I think Glanville's made it pretty clear that he was not going to be spilling the beans on this, and he's pissed off about who did. But let me see here. So detail the holding of an improper ex parte hearing conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick. And granted, he's not representing everyone, all the other defendants, so he's not going to name them. But you could easily just name, Jeffrey Williams, Rodalius Ryan, Quamarvius Nichols, Marquavius Huey. Who am I missing? Diamante Kendrick. It's 6 people. Am I missing? Yeah. Somebody tell me who I'm missing. It's like the 7 dwarfs. Can you name the 6 YSL defendants? I easily can. Violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which reads, what does that read? Assuring fair hearings and averting ex parte communications. Judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. And for the most part, I mean, I remember before all this drama happened, I had a discussion with Doug Weinstein, and somebody in the chat asked, Glanville's always cutting you guys off, or he doesn't give you guys a chance to heard. And Weinstein was like, no, I think he gives us a chance to be heard. It's like, I spoke too soon. But Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter subject to the following exceptions. And then they've got at least 4 exceptions here. I mean, yeah, let's see. Let's read them here. Would this at all qualify? Because Glanville, he's just so smug about things, but he apparently thinks he is in good standing here. You know, I mean, he even kind of said something to Steele the other day. He's like, Steele, you're getting out of line here. I can't remember what his exact words were, but he seems so smug about this. But judges shall accord to every person who has a legal interest in a proof. Oh, excuse me. I already read that. These are the 4 reasons why. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that. And I can't see how this would at all qualify, because I think you could argue this is an emergency, but you absolutely cannot argue with a straight face that this does not deal with a substantive issue or an issue on the merits. Of course it freaking does. So provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage. Yeah, and that, like I said, they already did not qualify for this one, but you just go down, it's like, oh yeah, nope. The judge makes provision promptly to notify all other parties of the substance of the ex parte communications. I mean, they emphasize in here that people need to know about this shit, guys. Judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court. That would not be Kenneth Copeland and his lawyer. Definitely nobody here qualifies. That does not describe Monday's meeting. If they give notice to the parties of the person consulted and the substance of the advice. Exactly. And then notice how notice is just like emphasized in here. You need to tell people about this shit. If you're gonna lock them out of the room, you need to at least tell them they're being locked out of the room. Judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities, or with other judges. So Kenneth Copeland is definitely not a court staff or a court official, and he's not another judge. So this does not fit in the bill here. Providing the judge makes reasonable efforts to avoid receiving factual information that is not part of the record. And even if we did, decide in some bizarro world that, yeah, Kenneth Copeland, he qualifies as a court official, it still fails the second test, because receiving factual information, although you could argue, because it's debatable whether it's factual. But yeah, no, it's just every step of the way they fail things. Sorry if you guys are hearing the sirens. It's the excitement of living in downtown LA. All the emergency crews going by here every 5 minutes. But let's see here. Judges may, with the consent of parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. I wonder if Glanville thinks this qualifies, because this isn't a civil case. He's not, and at least in California state court, judges cannot participate in criminal plea deals, or actually maybe that's, but yeah, this is not it again. But yeah, no, I don't think any of those qualify for what we're doing here. So this is obviously the point that I mean, that's Weinstein's whole point. He didn't include this stuff in here because he thinks that it somehow saves Glanville. He's making his point that he needs to recuse himself from the case. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. I'm sure Glanville would take exception to the whole idea that he coerced somebody to testify, but yeah, I mean, I don't know. It's like, why can't, and I don't understand why he doesn't want to just release the transcript on this. He got a transcript. He had the court reporter there as a CYA to get it on the record because he respects the rule of law or whatever. It's like, so just release the transcript. But defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. And I love a good footnote. There's a 4 footnote on the critical stage. Let's see what it says. Oh, it's not a good footnote. It's just a definition, but that's okay. A critical stage is, quote, one in which a defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. So I think really any point of this trial would qualify as that, but especially the testimony, anything about Donovan Thomas and the crucial witness. Yeah, the only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the sworn witness into testifying. Motion should be assigned to another judge for reconsideration. If the court denies the relief in the motion to recuse, Kendrick requests that the court make a specific factual finding, which Glanville says he's going to do, which reminds me I need to check the court file to see if he's filed that yet. But he didn't say much about it when he rejected it outright. But should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial. Yeah, right. Due to the ongoing bias of the court, as evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review, meaning that would allow them to take it to the appellate court instead of having to wait for a judgment and sentence, like for the trial to be over, and he denied that. But and that's it. And he's got his affidavit, which usually just repeats stuff here. But here, let me pull up how Glanville ruled. It was a quick thing, and like I said, I didn't even know about the motion until I started hearing him talk about it.
You read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I'd invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right, I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And then if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
if you grant that certificate,
It-
You were always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree.
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
We didn't really miss much after that. And that's when I first heard it. I was like, oh, there's a recusal motion brought, huh? And you can go into the Fulton County Superior Court records and pull that up. But they give you the first page for free, and then you got to pay it's like 50 cents a page, which, especially for something like that, it's not that big a deal and it's worth it. But something happened with that website, and I got to go into another browser, but I got to update my my debit card number because it's an old one that they've got in there. And anytime I try to do it, it tells me that like it's the wrong URL or something. And I wonder, because that site was down for a couple weeks because they all got hacked. But like I said, I just got to try it in a new browser. But I'm like unable to pay for documents on there right now. It's kind of annoying. So especially for that one, because I wanted it right away. But I actually just messaged Doug on Twitter, and he sent it to me, like right from the courtroom. He sent it to me. I was like, oh, all right, and got it all around. I noticed Thugger Daily put it out there. He's got a huge following on Twitter for the trial. It's pretty cool. But yes. So I mean, does anybody have any questions or anything about what's going on? Like I said, the Georgia Supreme Court not telling Steele, no, actually, you don't have to go to jail was pretty common. I mean, the idea that they would have let him go to jail on Friday, no way. So a lot of people are like, oh, this Georgia Supreme Court ruling is such a smackdown on Glanville. It's like, I mean, it is, but it's not quite yet, just because that like jail order is so outlandish, you know. But and no, I see somebody on YouTube, not today. Fulton County didn't get hacked today. I'm talking about the hack that happened like 2 months ago that they've like supposedly recovered from, but I'm wondering if that has something to do with the website problem I was experiencing. But will the Supreme Court look into Glanville? No, I mean, this is just going to be, like you said, reviewed by the appellate court, but there really is not like a recusal motion here that they can do outside of like what we just talked about in the process that they're going through now. But gosh, what was let me pull up Max Shard. This is a short one. He's talking about the transcripts. And this is when, in the more Judge Glanville talks, the more I think he kind of screws himself. Because when you hear him talking about this stuff, it's like, okay, so you know Max is like right? And really
any impeachment evidence that is different or contradictory from anything that Mr. Copeland has stated on the stand so far from the state?
Madam.
Your Honor, we will share anything that we have heard today different or any other day different from what he has stated on the stand in an email to counsel, and we will copy the court this afternoon.
All right, Mr. Shard, is that the extent of it? You've asked me before about anything else that was said purportedly ex parte. The court is still kind of combing its way through that, okay?
And Your Honor, just to be clear, my inquiry of the state was not limited to that ex parte communication. But yes, Your Honor, I have asked about the transcript, but respectfully, I just not trying to ask about that every day out of respect.
No harm.
Yeah.
We're working on it, and you certainly, if it's appropriate, will receive or the opportunity to, whatever statements that may be relevant to your inquiry before you begin your cross-examination. You'll have that. Should that be bear upon it? Okay.
Thank you.
All right. But as for the state's inquiry, Miss Love says she will forward anything else to you that she becomes aware of.
Understood.
Because the state has a continuing obligation, of course, to provide you with any Brady materials.
Yes, Your Honor.
Or impeachment. Okay. All right. Anything else?
Yeah, it doesn't really inspire confidence here. And let me answer some questions here. Alec, thank you for the super chat. It says, does Woody's testimony so far hurt or help Young Thug? Could you see him pleading the fifth when the rental car situation comes up? So because he's been granted immunity, if he tries to plead the fifth again, it's going to be some drama. It's going to be the same thing where he could be held in contempt of court. So if he does try to do that, it's going to be problems. Like, it's not going to last. And frankly, so far I just have not heard anything of substance in his exam, but we haven't quite gotten to all the good stuff yet. We're just getting into the gang stuff. He was testifying about YSL versus Young Slime Life. But right now, I think it's overall, it's hard to say, but it definitely hasn't hurt Thug, but he just hasn't said anything incriminating. It's like them going over all these photos of them. It's like, yeah, we know that they were hanging out, years ago. And Simone trying to make the point that they weren't friends anymore and that they had a falling out, and that Woody told Marquavius Huey, be careful who you hang out around with. Don't hang out with Thug anymore. And it's like, it's so hard to follow this and figure out like where they're getting here. And they're trying to lay the foundation for all this stuff. But it's like, it sounds like a bunch of guys in their, teens and 20s who hung out and went a little crazy for a while and then all kind of grew up and like, I don't know. It's hard to really make this come across as like a scary9 especially when you see the photos and it's like they look like skinny little kids, from years ago. It's like 9 or 10 years ago. And the prosecutors were just trying to show this like decades long conspiracy. But it seems like, DK, Walter Murphy, when he testified, he'd been in prison for all these years. So he hadn't even seen Thug in all those years. And I know they had that supposed trap house. That's what the prosecutors call it, that Tick was living in. Like, I think when the indictment came down or around that same time. So there was they were all like, Tick was in contact with Young Thug then, but I haven't seen his testimony so far as helping him. And it just takes so long for them to go through the exhibits. Somebody commented on the clip that I have on YouTube of the photos, him going through the photos, because I think that's one of the more interesting video clips to do when they put the photos up on the screen, because I know you guys like to see that, but oh my God, you guys, it takes them so long to go through those photos. And I think they changed the method halfway through trial, because I think they have to lay the foundation for why Copeland should be allowed to testify about this photo. Like, you can't just put a photo in front of the jury and have Copeland start testifying about it. So they go up to him and they show him the photo and they say, do you recognize this? Who are these people? And then after that, they go and present it to the jury and ask him about it. And oh my God, it takes forever. And somebody like Copeland, when he's the kind of witness where kind of anything he says is interesting. So the back and forth when they're showing him the photos is kind of interesting. But the photos aren't actually being displayed at that time. So most of the time, I don't even post that stuff. I'll just cut it out and wait until the photos are actually being displayed on the screen. And when you do that, you just realize how long everything takes. It takes them forever. But they were doing that with Copeland's testimony today, the photo lineup. And somebody commented on YouTube, and, who knows who they really are. But I noticed they had a 1961 in their user handle. So I'm like, oh, that might be his birth date. But he says, I've been a trial lawyer for 30 years, and this is one of the worst direct exams I've ever seen. And I'm like, oh, dude, that doesn't even include all the downtime for them going through their exhibits like that. But it's like, yeah, what is the point of this Kenneth Copeland stuff? It's hard to get into it, Here's an attorney. Thanks for sharing your thoughts on this. In circumstances, yes, I've been excluded from court for such meetings, usually when a witness is uncooperative. But this is usually done before the witness takes the stand. Yeah. The only situation that I have that's like quite similar to this, and it's really different, but when I covered the Kobe Bryant's crash photos trial, when Vanessa Bryant sued LA County for doing all this just disgusting, morbid stuff with the Kobe Bryant photos, like showing them at bars and stuff. It was so bad. And they were all just lying on the stands too. There's so much perjury in that trial. But they had something with the juror, like the judge cleared the courtroom and said, he had something to discuss with the attorneys. So we're all out in the hallway, the reporters are, and a few minutes go by and Vanessa's lead attorney walks by and I just say, oh, what's the meeting about? And I'm not kind of joking, not really like expecting him to answer, but that's my job, right? To ask questions. And Lewis, the attorney, says, it's a issue with the juror. So I was tweeting about the trial and I tweeted, somebody says it's an issue with the juror or something that this meeting is about. And the next morning I walked in right after it happened, but the judge just went on a tear and he was like, Meghann Cuniff's tweet about this juror, I want to know who told her that, and like told all the attorneys that he was going to like ring them up and like put them under oath and demand to know. And Lewis just like immediately fessed up and was like, yeah. So like I said, it's really not the same situation at all. I mean, it's not, no. It's not an ex-party thing. It's not. It's just it. Yeah. No, it's not the same thing. Let me see if I can get. Oh, Alec, is Woody trolling the state or is he serious? Oh, I think he's trolling the state. Like he's having. I mean, I think he wants to troll Young Thug too, but I think he is a little hesitant to just straight up put Young Thug in prison for 30 years, even though he's testified that they had, a falling out and they're not friends anymore. And he has a personal problem with them. I think I'm not sure. He's definitely not just like raw prosecution. And he really hasn't said much that's like incriminating. He's definitely sticking with the record label thing. I mean, he said things that I know Brian Steele is going to latch onto and cross, where the whole reason he met Young Thug is because they were at a studio together and Kenneth Copeland wanted to be a rapper. So Brian Steele's whole narrative on this is that, they all wanted to be rappers, but Young Thug was just a really talented, hardworking guy. And all these other people like Tick and stuff were not that talented and they were prone to crime. So it's going to be really easy for him to get into that line of questioning with Copeland. But right now we just haven't gotten into really much of substance with Copeland still, which is kind of amazing because he's been testifying for 2 days. But yeah, so I think he's trolling the state, Alec, but we'll see if he starts to get a little more serious. Yeah, Woody appears to be getting tired. Not sure what to expect from him day to day. Yeah, and that's the thing. As this drags on, like especially, do you guys remember when Tick testified? He was on the stand for like 7 days over 3 weeks or something. I mean, it's just crazy how long this stuff stretches on. And that definitely affects, just everyone's mood, first of all, and then just how the testimony is coming out and that kind of thing. Somebody says, hey, Meg, I'm so sad I'm late. April, you're always on the chat in the mornings. Yes, thank you. Thank you so much for saying hi and all your support. You're one of the ones who watches the stream when there's like 25 people on the stream, But yeah, things have really blown up on the channel in the last few days. And I'm glad. I was like, this is why I've been paying attention to this trial and clipping all the freaking boring surveillance camera testimony from cops that just drones on and on, because here we go. Yes, Coco, you've got the news. Appellate court set emergency bond. So yes, Brian, that's the big news and why we're here is Brian Steele is not going to go to jail on Friday. So somebody asked if jurors are getting paid for being off work. They could have some arrangement with their employers. A lot of employers offer extra days off. And then I think the rate in Fulton County is like $20 or $30 a day. It's online. If you Google it, they have their dollar amount written there. But Somebody noticed the fact that I notice my viewers. I do. I try to notice you guys for sure. I need to get a little more stacked here. I've got TikTok and YouTube going right now, and I need to get some kind of moderator in here to help me. But like I said, I'm actually paying my friend Shadra to go through this one video and delete all the racist comments, and she's excited about it. She's like, honestly, it's kind of a dream to like have my job be to just go delete racist stuff. But one video in particular, I was looking at the comments. I was like, okay, I've got to do something about this. Like, but as the crowd gets a little bigger, Miss Bumpus. Yeah, let's bring up Bumpus. Somebody wants me to talk about Caleb Bumpus, who's was Woody's attorney on Monday. And this is when Jonathan Melnick appeared on Friday and said that he had non-refundable plane tickets. And he was just like, Judge, I'm not going to be here. I really wanted to be like, where are you going, dude? Cancun, Europe? Let us know. Some kind of idea about where you're going. But Caleb Bumpus appeared for Woody, and Kayla is definitely the one that Glanville thinks leaked this meeting info to steal. Because let me bring it up here. She, here we go. She was like, "Okay, am I excused yesterday?" And he's like, "Not so fast." Let's see. The video here.
And I propose an order.
Yeah.
Okay, can I see it, please?
May I approach?
You can.
Time here is
Okay, I'll mark this as the next court's exhibit in order. Do you have a formal order that you're going to prepare with the style of the case and the case number?
Yes, Judge. That's just his signature. I prepared an order and I filed a motion with the clerk's office. I'm waiting on a file stamp.
All right, okay. Mr. Copeland, let me hand you. This document. Did you read and sign that document?
Yes.
All right. Did you have an opportunity to talk with Ms. Bumpus, your satisfaction about pros and cons of her withdrawing as your counsel in this case?
Yes.
Do you wish for her to go ahead and withdraw as counsel?
Yeah.
Okay. All right. All right. Let me have that back in mind. Okay, I'll mark this as the next court exhibit in order, madam. We got it. We'll just mark it as the next court exhibit in order. Do you need a copy of it to file with your? Because it'll be made part of the record. But do you need a copy of it?
No, Judge.
Okay. All right. All right. So I will go ahead and authorize you to withdraw as his counsel in this matter. Okay.
Thank you, Judge.
Okay.
I'm excused.
Not quite yet. Madam, as a result, I'm going to also have you appear on the 25th of June. I have filed an order to show cause, and I'm going to give you a copy of it. You can read it, acknowledge it, just that you received a copy of it. And we'll see you on the 25th of June at 9:30 in courtroom 1C.
All right.
So you need to be here for that day, okay?
Okay.
All right. We'll see you then.
So yeah. Order to show cause. Order to show cause why you should not be screwed. That is not good for her, but also, I mean, she's just going to get into the same appeal that Steele's in. But the 25th, which unfortunately isn't like too long from now. This is 2 weeks from now. It should be interesting to see how much Glanville is willing to double down on this. because I mean, everyone is criticizing him for this. Is getting a lot of national news, and law journals are writing about it. I saw the Atlanta Journal-Constitution did a big article where they just quoted all these people trashing him, talking about how he was like taking everything way too seriously. And I didn't see where it printed, but I bet it ran on the front page. So that's like being probably distributed all over the Fulton County Courthouse. So I mean, he's definitely under it right now. But let's see what else happened today. We played the recusal motion earlier. We played the transcript one. I talked on Fox live now from Fox this afternoon, but I haven't. But yeah, if anybody has any questions or anything, let me kind of scroll through and see here. But they're back tomorrow. Glanville claims 9 a.m., which is 6 a.m. California time. It's like, gosh. But I swear, I don't think they've ever once started at 9. They once got started, I think it was like 9:15 or something. So we'll see. We'll see how quick they go here. But I was going to bring up the order, the actual order that he released he issued for Caleb Bumpus, because I wouldn't be surprised if he tries to give Caleb Bumpus more than, well, actually the max is 20 days for criminal contempt. So but I bet he gives her 20 days for sure. Like Glanville, and just the way he was with her, he's just like, all right, see you then. It's like, oh, she's fucked. But I'm sure she'll be able to kind of latch on to the same representation that Steele has. But here, let's pull up the order, because it's not just for her, it's for everyone who attended the meeting. But it's like, do they think that Simone Hilton is the one that leaked it? That'd be wild if it was. She turns out to be like a mole for YSL or something. But yeah, it's 25th day of June at 9 a.m. in 1C. Like I said, that's a disappointing amount of time that we have to wait for that. But especially when you cover all different cases, your calendar just starts filling out, and you're like, oh man, there's a lot going on over the next couple of weeks. Somebody asked on TikTok how they remove the judge. They can't. They're screwed. They already tried. It's a remarkable case, and I think, I mean, we've definitely, like, attorneys trying to recuse a judge in the middle of trial and him refusing, it has surely happened before, and will happen again. I mean, who knows? It could have even happened today in a case somewhere in America. But the thing that makes this case so unusual is how long it is. Like in some trials, like if it's just a total disaster, the judge is an asshole, he's just making dumbass rulings left and right, like what the hell, the trial's over in 2 weeks or something, or it's over in a month or something. The trial will be over in 2025. It's like, wait, what? It's kind of crazy. So really, the people who live in Fulton County and Atlanta have the most power here. And, I mean, Fonnie Willis is the elected official in charge of the DA's office. So somebody asked about the FU email, because Jonathan Melnick, who was Woody's attorney on Friday, Brian Steele said on Monday that he wrote some kind of FU email to prosecutors or something when they told him he wasn't like really representing Woody or something. But no, that hasn't been released. I guess we could ask, I could. And one thing I learned in journalism is if a question sounds crazy, that means you should definitely ask it. But and I think that's one thing that's really getting lost in the blogger age. Like Doug Weinstein, like just send him a message and ask him if he can go on the live, I might just email Jonathan Melnick tonight and see if he wants to send me a copy of that FU email. I mean, because there's no harm in asking at all. The worst that's going to happen is he's going to ignore you. Or maybe he'll send me an email back that says FU. But no, chances are maybe he won't give it to me, but who knows? They all seem pissed off enough. They might want to. That'd be awesome. I should. So yeah, that's the fun of being a reporter. You gotta be creative like that. Don't just latch onto Flax and write up press releases, But guys, thank you so much for tuning in and for all the love. I see the people I got 630 on TikTok, 1,470 on YouTube. It's tempting to just go on forever, but I've already been on for an hour and a half. I'm gonna ruin my voice. But again, watch the replay. Thanks for saying hi. I'm going to post some more clips on TikTok. I think I've pretty much got the day covered on YouTube. So if you guys want to catch up on the clips, go to YouTube. But I'll be back tomorrow, and I think it's just more Copeland. Like, I wouldn't be surprised if Copeland's on the stand like through next week, because I mean the rate they go in these exams, it takes for freaking ever. So, but the cross on him is going to be really good. I mean, Max Shard is going to have a really extensive cross because he represents Shannon Stillwell. We've heard a lot about Stillwell. I mean, Stillwell and Copeland were really good friends. And then all the Donovan Thomas stuff is very relevant to Stillwell. And then, of course, Brian Steele. Brian Steele's is going to be like the epic cross. So that'll be the one to watch. But like I said, I wouldn't be surprised if cross doesn't even start till next week. But if somebody asked if the show cause hearing will be televised, yes, I think it will. They've been streaming every other hearing, and I mean the Atlanta TV stations and Law and Crime. So I can't imagine they would miss this one. But that's one disadvantage I have, just being a one-man show here in California. I'm just grateful to the Atlanta Journal-Constitution and the TV stations there that have like fought for this over the years and made sure that we have access. And really, we should, I mean, for all of Glanville's faults, he has not turned off the cameras, and I don't think there's any risk that he will. And he totally could if he wanted to, but I don't think there's any risk that he's going to. Somebody asked if Steele was correct bringing it to the court's attention. Yeah, I mean, as Steele said, he had a duty to his client, an ethical duty to like raise this, so he had to. But anyway, thank you guys so much. And watch the replay. I'll try to clip out just my talk with Doug and post it just separately. But hopefully we can get him back on there. And I'll try to get like Max Shard and Brian Steele would be the obvious one. But man, he's like such a rock star, and who knows. But I gotta send some emails. But yeah, thank you guys. Somebody says thank you, Meg, and I love you guys. Love the fans left and right. 2 new messages. I gotta get somebody to help me read these, but. Thank you guys so much, and tune in later. I'll be streaming tomorrow. I don't know if I will actually go on camera, but I'll be streaming the proceedings, and I'll have the things set up later today. So thank you guys so much. See you guys later.